Apart from that, on this 8th March, we will have International Women's Day. We will celebrate, and there will be panel discussion where learned women speakers will be there as a panelist. And there is one very interesting program on character Draupadi from Mahabharata, and the role will be played by Anjana Chandak. So we will share the link of the same shortly. You can register with that. Apart from that, one more very interesting program on 13th March. So that program is on succession through family trust, inheritance law. In that, both all the speakers are coming from Mumbai. Mr. Gautam Doshi, so he's a very renowned chartered accountant and expert on the subject. Mr. Yogesh Thar, he is also a big time expert in this subject, and Advocate Mrinalini Desmukh will also be there. So she will be discussing on all daughters' right in these kind of inheritance matter. So the entire day, this is the entire day seminar, and we will share the link of that. So this two programs we have scheduled for the March, and for April also we have a conclave on ESG, Gift City, and GCC. Apart from that, one conclave on IBC. For the month of May, also, we have planned the information that we will share later on. Apart from that, I always keep a point that you will all be enjoying these programs once you become member of ACA. You will be getting all the information. So I'll request Vishal to share the membership link in the chat
Sure, sure,
box. And those who are
sure.
not member of ACA, I request all of them to become member. And please give suggestions, and feel free to connect with us. We are phone call away, and give suggestions on even topic as well. You want to have discussion on any new kind of topic. So I think this is something today. This data protection and digital privacy, which we are going to discuss, is a very important and pertinent subject as on date. And definitely, I think after deliberation of Dharmendra ji, we all will be enlightened. So thank you very much, and also welcome and thanks to mentor of this committee, our honorable past president, C. Indu Chhatra sir. Sir, thank you very much. Your guidance and your mentoring to this committee is doing really well. And friends, let me tell you that every month we are organizing two group discussions. So this is a great initiative from all of us. So please enjoy. Thank you very much.
Sir Neeraj ji, sir, memento for Dharmendra ji.
हाँ बस आप शेयर कर दीजिए एंड विल रिक्वेस्ट इंदू सर if he can share his wisdom of words.
Sir, is the screen visible now? The
Yeah,
memento.
screen is visible. Screen is visible. So this is the digital memento we give, sir, in digital program. Yeah, Indu sir. Sir, unmute कर
Good.
लीजिए अपने आप.
Yeah. Good afternoon, everybody. It's a pleasure to attend these group meetings. And this evening's speaker is a the way, when I was hearing his biodata, it was so interesting that he's full of knowledge. And this subject which he is going to speak on is a new subject to everybody. Thank you so much, Mr. Kapoor, for joining us. Thank
Thank
you
you,
so
sir.
much.
My pleasure, sir.
Sir, we can start, sir.
Okay. So, shall I share the screen or?
Sir, as you wish, sir.
Okay.
And it is a request to all the participants, please post your questions in the chat box, and sir will be addressing the questions after his speech.
Is it visible now?
No, sir, the screen is not visible. So now we can see your screen.
Good afternoon, everyone. Good afternoon, Indu sir. And
Good afternoon.
first I will start with this is the first comprehensive digital personal data protection act in India. And why we need this act? First, I will deliberate on this. What is the conceptual foundation of this? DPDP Act is basically a constitutional obligation or consequence of the of Puttaswamy judgment which happened in 2023. And in that judgment, the Supreme Court first highlighted the right to privacy thing. And in that judgment, after that order, there was a feeling that some legislation needs to be formed because Supreme Court said there's right to privacy. It's a fundamental rights under Constitution. This judgment made three things very clear: that first, privacy is intrinsic to human dignity. Privacy applies not only against the state. Is it my PPT visible to everyone?
No, sir, the PPT is not visible. Only the window is visible.
Let me check. Sorry for the inconvenience. I am trying to stop sharing.
So now it is.
Okay,
So,
thank you. Thank you, sir.
Thank you,
Thank
sir.
you. So I was saying that the second, privacy applies not only against the state but also the private entities also. From this moment, the data protection was no longer a matter of policy or convenience. It became a constitutional obligation. This was the primarily background of DPDP Act, the constitutional consequence. It is not, DPDP is not a policy choice basically. And we all know the second thing is that the rapid digital explosion in our economy. We were safeguarded when such a digital radicalization has never happened, but after digital economy, it was very much essential. The corporate house holds more digital data or citizen data than government. Most organizations become data custodian by default, not by design. And DPDP is the course correction mechanism also. And there was also some deficit of trust among citizens also for various incidents like digital arrest happened. in recent past. So, my friend, I request everyone in coming 60 minutes to drop one word consciously from your mind, that compliance. Because DPDP, Digital Personal Data Protection Act, or in short we say DPDP Act 2023, is not another compliance law, is not another a regulation or IT regulation, and not something that can be solved only through by making policy or privacy notice, something like that. It's a deep control law. And why I am saying it's a control law? Because it fundamentally decides who controls the data, what is the purpose behind collecting the data, how long data will exist in your system, and who is accountable. Most important thing, who is accountable when data goes wrong. And when something goes wrong, the impact is no longer logical or technical. It is financial, reputational, and governance driven. Why it is financial? Because the penalty amount in this act is as high as 250 crores. No threshold limit has been defined yet. We are waiting for the notification. The person who has been interested to use that data can face huge financial obligation. It is reputational because there might be a deficit of trust if any data breaches happen and the data is compromised of data principle. I will explain this terminology later. So there will be a reputational damage also. And the governance driven, why I am saying? Because why data is collected, how long it will be retained in your system, whether processing is lawful or not, or whether consent is valid or not. It's a business decisions. Information technology department or IT department can secure your server only, but IT department cannot take such kind of decisions. These are business decisions. These are governance driven decisions. My friend, what I will say that this law will be discussed more in the boardroom rather than server room. DPDP is a principle driven governance law. DPDP works on what, not how. DPDP defines lawful purpose, data minimization, consent validity, reasonable security, and accountability. DPDP does not define, rather than you will say this, that it does not control or it has no laws on such on thing, that which software to use, what are the database, exact database design, what are the consent layout, which is a very important concept in this act, and which firewalls or tool company should use. If we can justify 3 or 5 principle, then DPDP Act compliance will be there. like the most important five: lawful purpose, data minimization, consent validity, and reasonable security, and most importantly, which was not earlier in any act, accountability. Your IT department is only an enabler. IT department will configure your system, applies control, execute instructions. But IT department will not be accountable person. The board will be the accountability. The board which sets risk appetite, management sets, designs internal control. Company and directors will face penalty in case of any breach. And if in case of any breach, that earlier excuse was IT team was responsible, DPDP eliminates such kind of defense. In DPDP clearly distinguishes between ownership and execution. We cannot say now this happened because the IT team made a mistake. Technology can be outsourced, cloud can be outsourced, vendor can be outsourced, but accountability cannot be outsourced. DPDP Act regulates our behavior, decision making, and responsibility. Behavior means whether the data collected is lawful, whether the purpose for which data has been collected is the intent what it has been collected, whether it has been excessively utilized, whether the data retention is not beyond the actual requirement. All these are decision making and governance driven decisions. That is why I said DPDP will regulate behavior, not bandwidth. DPDP creates direct enterprise level exposure. There might be a loss of customer and employee trust due to data breach. Regulator scrutiny might be there. And these are not IT risks, these are governance and financial risks. IT team cannot decide lawful purpose, balance between justification. But DPDP decisions are business decisions. Why do 50 users have access to HR data? These are the business decisions. Why marketing department needs this information? These are business decisions. That is why I am saying, my friend, the DPDP fails. The defense IT was responsible will not survive regulatory scrutiny. From IT earlier act, it is not that there was no such provision in the early act IT Act 2000. There was a provision in section 43A and SPDI rules. It was a very novel concept which at the time which was framed. But we have to keep in mind that at that time our economy was internet based economy, and now our economy is driven by data. Our economy is radically digitized economy now. Though earlier framework was very narrow in scope, incident driven, IT centric, and most importantly, that there was weak in governance and accountability. It simply could not match the scale, speed, and complexity of modern data usage. Section 43A was built for the internet age. DPDP is built for the data economy. And you will also notice that the fundamental mindsets shift also. Earlier, compliance thinking was control centric. What was that? We have to install tools, we have to make policies, we have to assign responsibility to IT. But now a judgment centric, define purpose, design data flow. We have to update our ERP, CRM to embed all such controls. We have to do continuous monitoring. These are the judgment centric governance mindset. And this is a shift from technical compliance to enterprise accountability. DPDP converts digital convenience into digital responsibility. Earlier, there was growth without responsibility, but now will be a growth with accountability. It is not that there was no such control or mechanism to regulate data. We are regulating data because accountability was not there earlier. And there are two ways to approach this. First, that there are two kind, if we mind bifurcate the mindset of two stuff, reactive and proactive. If we consider as DPDP for reactive organization, वो अभी तो penalty probably will start doing something when the penalty provision will be activated. Friend, this act was judgment was passed in 2070, and after a lot of iteration, that act was passed in 2023, and and after almost 2 years and more than 2 years, the rules published in November 2025, and the 18 months time has been given for the activation of penalty provision, and which will be fully activated in May 27. So 18-month gap has been given. Government of India wants to implement this act in a phased manner, and sufficient time has been given. So reactive organization will do that. We will implement or control our system when any data breach happen, or when we will face penalty and reputational loss. And proactive organization will treat DPDP as trust infrastructure. They will design their system. They will develop their ERP to create more robust governance mechanism. This will gain credibility with regulator, with vendors, with customer and investor. DPDP is not stopping the data use. What it will doing that use data more responsibly, more accountable, in a more accountable manner. And there is a fundamental shift in legislative thinking philosophy also. This act is very short, only 7 chapters, 44 sections. And most importantly, that there is no proviso in this act. This act is short, principle based, technology neutral, and governance driven. It applies to digital personal data, focuses on the rights of individual, on data principle. Its data principle means about you and me. It's a very empowering concept also. In other act of European Union GDPR, they termed it as data subject. I will explain little bit here. And data principle is that data belongs to me. I own this data. I have full agency and control over this data. And nobody can use this data without my consent or saying so. If I have given the consent, only in that context you can use my data or utilize my data. If I have not given any consent, nobody can use my data. This is what about data principle, you and me, and other act. GDPR, it is defined as data subject. Very empowering concept. This act applies to digital personal data, and it's very user-centric law. And places huge accountability to data fiduciary. And whose data fiduciary? The data which has been entrusted by principal to use is known as data fiduciary. There is a primary relationship and contract between data principal and data fiduciary. Data fiduciary can share data fiduciary as a CA or as a practitioner chartered accountant. We are both, sometimes we have to play the role both, sometimes as data fiduciary and data processor. And when data is shared by data fiduciary to process this data in the defined manner, then that organization or concern is known as data processor. Primary relationship contract exists between data principal and data fiduciary. Secondary, which is basically governed and by contract between data fiduciary and data processor and regulated by Contract Act. And this is also a contract driven, the relationship between data fiduciary and data processor. DPDP is very short in design but heavy in responsibility. I have said that it is a very small act, 7 chapter, 44 section only. The law begins with rights of data principle. In between, there is section of obligation. of data fiduciary, obligation of significant data fiduciary, but it ends with the penalty enforcement, rights, obligation, and penalty. In three way, the whole act has been designed. What exactly is personal data? Any data about an individual who is an identifiable directly or indirectly by reference to such data is known as personal data. With the constitutional and legislative foundation I have explained to you, now we will move to the governance across its life cycle. And for this life cycle, we have to understand what is personal data. And the life cycle in one line, from the collection to erasure, from the birth of the data and to death of the data, means deletion of the data. The law does not care about labels, whether data is personal or official. There is no such thing of official personal data. Official email IDs are company data. Employee data is covered under employee contract. If a natural person can be identified from the data either by itself or when combined, the DPDP provisions will be triggered. Even the business model is B2B, the DPDP provisions will be there. It's a misconception that we do not deal with direct customer, the DPDP Act will not apply. Because in B2B business also, in the CRM module, customer relationship module, we have a various spokesperson data. I will give you a few example why the in CRM module, the DPDP Act will be or B2B business rather than that's DPDP Act will be applicable. We have a employee data, we have a director's KYC, we have a vendor spokesperson data, we have a government official spokesperson data. In the CRM module, we record WhatsApp log, we record their nature, hot head, cold head, their taste. All these are identifiable data and can be related to individual. So even in B2B business, DPDP exists. Governance obligation will begin when there is a lawful purpose, consent, security safeguard, retention. In DPDP, data classification will start with people, not with systems. And what is not personal data? DPDP is not a corporate secrecy law. It does not regulate data that relates purely to legal entities without any human linkage. The protection of DPDP ends when a human being enters into the system, into the picture. If the corporate data is linked to an individual, identifiable individual, DPDP is triggered. A company name is not personal data, but the director's name attached to that company is personal data. A GST registration is not personal data, but the authorized signatory's mobile number is personal data. A vendor master is not personal data, but the vendor spoke contact details are personal data. Most of the organization, we think that this is company data, so DPDP does not apply. This is statutory data, so privacy law does not apply. DPDP corrects such thinking. This law is not interested in company. This law is interested in people, individual. Our systems are full of personal data, directors, KYC, employees, vendors, consultant, government officer data, auditors and professional data. Huge personal data are into our system. And there are two kind of identifiers. Direct identifier, as we all know, that name, mobile, email IDs are direct identifier, and most dangerous is indirect identifier. Direct identifiers are highest degree of sensitivity. However, this act is not defined any like in earlier act. There is a sensitive data such definition was there, but in this DPDP Act there was no such provision of sensitive or non-sensitive data. This is also a very unique concept, because if act has been designed in such a way that this clause is for sensitive data, this is clause for the normal data, this act could have been more complicated. What they did, that the obligation totally shifted to the person who has been entrusted to use that data, means data fiduciary and significant data fiduciary, to a person who will burn the everything. Not so. There is a huge good way of designing of act also, that they have not designed act in such a way sensitive data or non-sensitive data. They have defined the users who are using this data fiduciary and significant data fiduciary. I will come into that. See what is who are the significant data fiduciary. Data collected as part of employment, data collected for statutory compliance, or personal data. We have to answer for direct identifiers. We have to answer three hard questions. Why exactly we are collecting this data? Is this purpose lawful, specific, and necessary? Can we prove consent or lawful basis if asked by regulatory tomorrow? We cannot say Aadhaar card was copied just in case now. PAN stored in Excel and shared on email. The board and auditor will ask who has access of such data. Why do they have access? Where is consent recording? How long the data will be kept in the system? When the data will be deleted? These questions can be asked by the board or auditor or direct. If you cannot defend that for direct identifier, why you are holding this data, better you should not hold such data. And for indirect identifier, that employee ID links with payroll, attendance, biometric devices, and access right, we can identify any individual. An IP address combined with logs and with time and access, we can identify location data with timestamps. We can identify any movement patterns of any individual. I have already explained regarding the CRM interaction history. In the CRM module, we maintain like WhatsApp log. We maintain the habits of individual to whom the salesperson has called. What are the like and dislikes? All these are recorded. And we all know that in data economy, peoples are identified by patterns, not names. If you reconstruct the identity of any individual, then DPDP will apply. And if our assumption is that our system do not store names, so DPDP does not apply. This assumption is legally incorrect. For indirect identifier, the question board may ask or auditor may ask, why was this indirect data collected? What decision does it happen? Who approved its use? How long it will be retained? Can the individual exercise right over it? If these questions cannot be answered, my friend, the defense will collapse. Over detailed ERP logs, CRM free text remarks, performance analysis, excessive monitoring. Data is retained because storage is cheap. We are storing the data. Someday it will be utilized. All these are governance failure, not IT failure. That is why I say that this is the first risk-based governance law. DPDP is not an IT act. It is a risk-based governance law disguised as IT act. So what are the, I have explained the personal data concept. Now, digital personal data. What is the digital portion which will attract the provision of DPDP Act? If any data collected directly digitally manner or collected physically earlier, now it has been converted and digitized, that data will fall under DPDP Act. DPDP is not a paper law. If we converted anything into a digital form, DPDP will trigger. Scanned KYC document, HR files uploaded into the HR module, physical forms converted into the PDF, WhatsApp image forwarded into the official systems. There is no escape route, my friend, if such incidents are happened in your organization daily. DPDP will attract. Once papers enters into the system, DPDP enters the conversation. That one line we have to keep in mind. Organization often believe that this is old data. This is only scanned for backup. This is internal use only. DPDP does not recognize such kind of excuse. If digitized, DPDP is applicable. auditor and board will ask few questions. What physical data has been digitized? What was the purpose of digitization? Where earlier it was the physical, now it has been where you are storing the data, and who is accessing that data, and what is the detention and deletion policy for such kind of data. Our HR data is more high volume, high sensitive and long retention personal data. Payroll and compensation, bank account information, attendance and biometric records. All these are personal data. It requires which law, for what lawful purpose it has been collected, and whether the consent has been taken or not. As this act is very consent based law. Most DPDP violation will originate from HR system. This is my perception. Finance data like employee reimbursement, vendor master are very highly sensitive personal data in the finance domain. In the CRM module, there's spokesperson data, email ID, call recording, meeting notes. All these are personal data. And if someone is profiling your data, there is also a very dangerous, and it's also comes under the personal DPDP Act. Productivity analysis, behavioral profiling, very much attack all these provisions. Many organizations assume that once data is processed or analyzed, it is no longer personal. It is legally incorrect. It remains personal data under Section 2. It often identifies individual. Now, my friend, what are the data life cycle? I earlier explained from the collection to erasure. DPDP is not a event-based law. It's a life cycle governance law. If we cannot justify the data, why we have collected, we cannot justify the collect data at the later stage. We have to justify at the first stage why we are collecting the data. We have to remember these 6 principles: collection, purpose, storage, sharing, retention, erasure. Failure at any single stage constitutes non-compliance. DPDP is very much design-centric act. It's a life cycle law, not an incident-based law. Earlier act was provisions of earlier Act 43A and SPDI rules was very much incident-based law. In collection, personal data will be collected only if there is a lawful purpose, consent is clear and informed. In first time in India, that consent taken not only in English, all 22 regional language has been given to take consent. This, as we all know, that we sometimes we have to explain the consent sort of thing, what is written in English to the person, that iska matlab ye hota hai. Now 22 regional languages are there. DPDP will kill habit that डेटा कलेक्ट करते हैं, बाद में देखेंगे कि क्या करना है. Think later approach will not work here. You have to justify on the very first day why you are collecting this data. Let us collect extra field. Storage is very cheap. That practice will not work here. डेटा कलेक्ट कर लेते हैं, we might need this someday. ये नहीं चलेगा. And purpose limitations. I want to give my practical or day-to-day example that you may have also faced. That whenever we go to some retail shop for coffee or some eating joints also, so they ask, I see that number of persons who are standing before me, that this was my assumption earlier, that 4 or 5 persons standing before me, and each time they come to close for the payment, the person who is standing at the counter asks, what is your number? And when you are standing at least 3 or 4% that behind, and you see that every one person is giving the number, and you also tend to give number, and as if my assumption was that this cash counter will open only after we will share the number. But that guy will never tell you for what purpose these numbers will be utilized, whether that number will be shared with your affiliates for some analysis profiling purpose, or that numbers will be shared for the profile for the loyalty points. That guy will never tell you. But now such excuse will not work. If they have to ask what purpose they are taking my number, if I have given consent that okay, I am sharing my number only for the loyalty points, only my numbers will be utilized only for that purpose only. I am giving you another example, that sometimes we take membership of clubs. We have to sign a form, we have to share our KYC. And from the very next day, our email boxes are getting numbers of mail. That though we fall in under that bracket or not, I don't know, that we start receiving mails of the high property, jewelry shop, or holiday destination. Whether we fall under that, that's a different thing. But we start means the person has sold our data. The intent was only to register, but it has been compromised. The data breach has happened. Such things will not happen. The purpose would be limited for registration only, for payment purpose only at the counter. We cannot collect excessive data. Purpose defines permission. In DPDP, authority will flow from purpose, not power. Storage is not about server. I have earlier told that it's not an IT sort of thing. It is about control. Reasonable security safeguards we have to take. Then what are the reasonable security guards here? There must be a role-based access, segregation of duty, monitoring and review. DPDP treats excessive access as a governance failure. Why the 50 people are accessing HR data? The question is not who misused it. The question is why the access was granted at all. So always role-based access, not purpose-based. Access is authority, and that authority must be justified. In DPDP, poor access design is treated as poor governance. We have to share our data for vendors, consultant, various agencies as well. We have to be very mindful and very cautious when we will share the data. In DPDP makes one thing very clear, that accountability never moves. If we are collecting data of our client for only company registration purpose, and we are utilizing that data for income tax filing purpose, for other purposes also, we cannot take bundled permissions. We have to be a incident based, role based permission. We have, as a CA, we are fiduciary sometimes, and we are sometimes data processor. If the purpose is defined, that okay, we are handling the employee's data only for the purpose of salary processing, then purpose is that defined, then our role in that case only for data processor, our liability is limited. But when purpose is not defined completely, and we are retaining that data, then we are sometimes in the huge liability bracket, and will be a data fiduciary. Sometimes we will be exposed ourselves. We have to change our onboarding engagement document for each client in future. We may outsource processing, but out accountability cannot be outsourced here. The forever data retention policy will go. His data will be kept for forever, even if the employee has been left, even the vendor contract has been end. We cannot. Data will be kept only for the as long as the law requires, as long as purpose exists. We cannot keep it for the forever purpose. Under DPDP, old data is not an asset. This will be termed as accumulated risk. Eraser is the ultimate test of control, my friend. In DPDP, deletion capability define governance maturity. If we can delete the data on the right time, then our governance is good. We have to update our ERP as well. We have to create some logics in our ERP system. ERP should be built for efficiency reporting purpose. DPDP will definitely force the ERP redesign. As I said earlier, that excessive collection, we have is normal corporate failure. Data collect कर लेते हैं, we will use in purpose. We have to be very specific at the very first day that why we are collecting the data. WhatsApp sharing, the Excel exports sharing should be stopped or minimized if only for the purpose only. Now, DPDP, most important concept about the consent, as this act is consent driven act, as I've said earlier. If data principal has not given any consent, the data fiduciary cannot use that data beyond that. Consent must be very specific. There is no such concept of implied consent. Bundled permission कर लेते हैं, काम आएगा. Personal data may be processed only for a lawful purpose and generally on the basis of consent only. Consent is not a procedural formality. It must be understandable. Consent must be purpose specific and must be proved before the authority. If the consent architecture is weak, then it will be a governance failure. Consent brings the accountability. And that consent must be free, informed, specific, unambiguous, unconditional also. And there must be transparency also when we are taking anything from the data principle. What personal data is collected, the purpose of processing, retention period must be clearly written there. I think what I expect that the banking organization, insurance organization will give transparency sort of notice to individuals that such personal data has been collected and we have processed your data in this purpose and we are keeping or retaining your data from since then. And if we have shared, they have shared your data, they will disclose on for to whom they have shared their data and for what purpose they have shared the data. These are the rights of the data principal to know who, where my data it gets in and where it gets out, who or on what purpose it has been utilized. These are the rights of the data principal and we have to aware of these rights because this act will not solve the whole problem if we are not aware of these rights. Act will not solve the problem itself. The data principal has to exercise their right and very mindful also while sharing the data. Management has to disclose, company has to disclose that what are the grievance redressal officer to whom they will contact if there any they got to know that data breach has happened. And the consent should not be given as blanket, but instead there are some provisions in that where the consent may not be required if it is for the larger public interest. I am giving you a small example. If some employees misappropriate fund or does something which is prejudicial to the interest of the company, then company will not ask the consent. Okay, I am taking your KYC for the investigation purpose. Without that consent, company can start their proceedings because it's a larger public interest. So in that consent will not be invalid at that point of time. And suppose the government has collected KYC for the scheme of some pregnant woman or some child, and that scheme has been expanded. So government, in that larger public interest, they can use that data, and that will not also be invalid consent. And I want to also disclose that this act is also applicable to the state authority PSU. Earlier it was not. It's a very forward-looking step, I will say, that not only the private, the government is also come into the encompass of this act. The law deliberately avoids prescribing specific technology. There is no mandate encryption standard कि ये इस method में आपको चलना. The reasonable safeguard is only volume of personal data are processed, sensitivity should be maintained. There should not be risk to harm to any data principal. Reasonable safeguard includes role-based access, segregation of duty, approval workflow. All these are security governance. Before explaining to this data nominee sort of thing, I will explain what is significant data fiduciary. I earlier told you that the Act does not segregate what is sensitive data or what is not sensitive data. What they did that the whole Act has been divided: data fiduciary and significant data fiduciary. Significant data fiduciary means significant obligations also to them. HDF status is not about size. It is about not about turnover. It is not about market capitalization. It is entirely risk based. The volume of personal data, the sensitivity of the personal data, the risk of harm can happen to the data principal will, if any organization is handling such kind of thing, that organization will fall in HDF category. Basically, bank, insurance, healthcare industry, edutech industry, and they have an additional obligation also. They have to appoint one data protection officer. They have to do a regular data privacy impact assessment also. Periodical compliances as there. They have to submit their report to the data protection board also. It means that even if the mid-sized company can be an HDF, where a large manufacturing company may not be under HDF. It is about the how risk data the company is handling. Now the data nominee. It is also a very unique and empowering concept under DPDP Act. And my friend, this is not in any act. This any provision, even in the European Union GDPR Act, such provisions are not there. What is data nominee? Data, even if we any person live after demise, the digital footprints are there. And for that digital footprint, the data nominees concept has been introduced. And that is explained under section 14 of the data nominee. It is like the money lying in your bank account. After departure, who will own that data? Who will be the owner of the social data belongs to the deceased person? We This is specifically relevant for auditor and us also, that employees HR records, email, ERP access, financial service, customer healthcare data must have a nominee. In our system, we have to enable the data nominee mechanism, capture and restore nominee details also, verify nominee request also. Ignoring nominee request is not a soft failure, it will be a statutory non-compliance also. And data nominee defines the dignity, continuity, and trust. It's a governance obligations also. As I explained that, moving to the next section of security and breach. Here, DPDP Act does not define which firewall to be used. They will define that if any breaches happen, what are the control failures in that scenario. When I am saying the control failures, that data fiduciary has to inform data principal as soon as they get to know that data has been breached, that breach of data happens. It is not that the 24 hours 40 as soon as the word is there. We do not, if something goes wrong, we do not want to know that. We want to know immediately that data breach has happened, and immediately notice has to be given. Immediately data fiduciary has to inform to the data protection board as well within 24 hours, and within 72 hours they have to submit a report that data breach happened because of this, and the further investigation is going on, and that they have to give a defined timeline. What is personal data breach? Unauthorized access, our wrong profiling, sale of customer database, phishing, identity theft, surveillance through aggregation. All these are personal data breach. Breach does not require a cyber attack. Under DPDP, a breach is about loss of control. All data breach may not be bring harm to the data principal, but data fiduciary has to inform to data principle, that breach has happened, whether that is harmful or whether that is financially loss to the data principle or not, that is a matter of investigation. But if any data breach happens, the data fiduciary has to inform within as soon as possible and within 24 hours to the data protection board. Section 16 permits transfer of personal data outside India, subject to restriction that those if any data belongs from India and goes outside India, then DPDP Act will be applicable. If any outside data comes to the India for the data processing, in that scenario, DPDP Act will not be applicable. But the data transfer also has to be very restricted. Accountability remains in India. Even when personal data is stored overseas, processed by foreign vendors, hosted on global cloud platform, the Indian data fiduciary will always be remain accountable. Outsourcing or cloud usage does not shift liability. For this, we required strong contractual safeguard. We have need possessor obligations as well. And I have already explained the HDF data principal, data fiduciary, data processor. Consent manager, this is also a very new concept. If any organization has huge data architecture and they are handling more than 4,000, 5,000 individuals' data, they cannot manage on their own. For this, there is a concept of concept manager also, who will be the agent of data principal to manage your data on your behalf. Now, various organizations are coming into this market. You can see that, but friends, do not go by that because all these are not yet registered under Data Protection Board. We have to let them register under, or let some notification comes into the public domain. Who are the registered consent manager? Then we can start. But still, it has not been notified yet. Large organization may have to take the help of consent management company who will manage the consent on your behalf. This is the new concept, and that only Indian company can do such thing. And data protection officer, only data protection officer needs to be appointed by the SDF only. Those who are in the following the significant data category like bank, healthcare industry, insurance, and those who are maintaining the high risk data. They they are not a IT administrator, but still they are compliance manager sort of person. DPO will safeguard governance while the consent manager safeguard your choice. But together, these roles professionalize data governance in India. What data protection officer, consent manager, DPIA, data impact assessment, all these activities will strengthen our data governance in India, which was not earlier. And data nominee concept also. This is also very empowering concept. Data Protection Board of India, as far as the latest notification concern, only four, there will be autonomous body consisting of 4 persons, not yet notified by the government of India yet. So let's see how it evolves. And it most of the time will operate digitally. The one concern is that no threshold has been defined yet. If what will be the severity of the breach, and then we will approach data protection board, because no, if there is will be no threshold, then explosion of complaint will happen, and how data protection board will handle such situation. This needs to be addressed by the government of India. But it's a very good concept which will bring transparency and confidence with data principle and the users as well. Why enactment doing enactment of DPDP Act 2023? Because it was after a lot of iteration this has happened. 2070 Puttaswamy judgment was passed and it was enacted in 2023. Before, from 2018 to 2022, lot of discussion has happened, and that at that point of time, personal data protection bill act name was there. Later it was changed at DPDP. And DPDP is very principle based law, but GDPR is compliance based law. It's very heavy in volume. That is why the PDP bills was also very heavy in volume and compliance. It was completely changed and to make user friendly and very short in nature. So DPDP is very principle centric, and GDPR is very compliance based law. Now the most important, that what capacity we can deliver as a professional to the organization. My friend, DPDP Act is very transformative. It is not incremental. This will change our audit universe. This act will find the place in our audit scope for every quarter, for every half year review, because the penalty is huge if any such breach or non-compliance happens. It's a new audit dimension, data governance. Auditors will now test purpose justification for data processing. DPDP directly intersect with IFC, enterprise risk management, and board reporting. Under DPDP, data governance becomes audit governance. If there is does not no breach in data, our governance is under full control. It's a governance driven act. I have told you earlier. We have to auditors or consultant like us can contribute in system architecture as well. We have to equip or to client that how to redesign our access matrix where the access data has been collected. We have to change in the system the retention logic. We have to embed in logic. We have to strengthen vendor access control. So it will create a strategic opportunity, especially for chartered accountants. CAs are like us are uniquely positioned because DPDP requires governance judgment, risk assessment, control design, documentation, and board level advisory. DPDP should not be seen as a threat, a cost, a technology problem. It should be treated as trust building framework, governance maturity. Friends, where we started that I will again ask you to forget the word compliance. DPDP Act is not about complying with a law. It is about regaining control over data. Thank you.
Thank you, sir. Thank you for the knowledge you shared. There are a few questions in our chat box. Uh,
Yes.
first is from Mr. Siddheshwar Pani. He's asking that if a person collects the data in his or her individual capacity and fails to protect, will the DPDP Act be applicable on him or her?
DPDP is not applicable to the domestic purpose only. Domestic purpose. If you are sharing data for the in domestic capacity, then that act will not be applicable. And if data is shared for the legitimate business purpose, then only that act will be applicable.
Okay. And sir, he has one more question. Like nowadays, when we go to any retail store, they collect our name, phone number, email ID, and but they do not take
Yes,
any
Vishal.
consent from us. So there is one more question. Like every day when we go out shopping, these retail stores, they collect our name, phone number, email ID, but they do not take any consent in writing from us. So, and tomorrow they sell out these data.
Hmm. So, DPDP Act will not activation will not be change the whole framework. We have to change our behavior also
Hmm.
while sharing the data. We have to be very cautious. We have to be, as in India, we are very more keen sometimes to share the data. आप पैन मांग रहे हैं तो मैं अपना पासपोर्ट तक देने के लिए राजी हो जाता हूँ कि ये लीजिए मेरा आइडेंटिटी प्रूफ. So we have to be very mindful when we are sharing the data.
Right, sir. Right. And one more question from CA Preeti. Uh, is as a statutory auditor of a company, do we need to check the compliances of DPDP Act?
Sure, it's a financial obligation. If there is any data breach, case has been registered there, and the maximum penalty 250 crores. We have to check what are the data risk committee should be, whether data risk committee is there or not, whether IFC
Okay.
control has been implemented. This is a
Right,
very
sir. Right.
much board-driven governance law, and DPDP is about regaining control over your data. We have to, it will make impact in the ERP design, internal control, vendor contract, audit trail, breach response, and ultimately board will be the accountable person.
Okay. Okay. Thank you, sir. Is there any other question from any participants? There's one more question, sir, from Ruchika Dhanukaji. Sometimes when we download some apps, they want access to our data. If we do not give access, we cannot use that app.
The very appropriate and right question. Thank you. The data minimization, what the data minimization principle section 7 says, that collect only those data which is relevant. If that is not relevant, we cannot collect that data. We sometimes only for the registration they ask for our photo access, they ask for our contact access. That should not
Right,
be.
sir.
Even from the last, my personal habit, I have changed that in last 30 days or 40 days, in my mobile, I am checking each and every app, at least 2 apps daily. What are the access has been given? I'm
Correct, sir.
changing that. We have to change
Correct.
our behavior, because this is I am again telling that DPDP Act will not control the bandwidth, but we have to control our behavior.
We have to be diligent while sharing the data and
Very much.
information.
Absolutely. Absolutely. No doubt on that.
So there is one more question, from Mr. Tanay Ghosh. If the company maintains data partly in physical format and partly in digital format, so DPDP Act will apply to him or not?
Those data which has been maintained in the digital format, for that data, digital DPDP Act will definitely apply. And that if any data which is maintained under physical form and is not never been digitized, for that data, DPDP Act will not be applicable.
Okay. Thank you, sir. Thank you for the deliberation.
Thank you. Thank you, Vishal.
So it was a very informative one. So can you share this PPT?
I have shared already with.
Okay. Okay. Thank you, sir. Thank you. Thank you
Thank you
very much.
everyone.